Hi, I'm Jessie Coleman from the Columbia Center on Sustainable Investment, or CCSI. CCSI is an observer organization at UNCITRAL's Working Group 3 on ISDS Reform. Investor-state disputes often affect the rights and interests of others who are not formally party to these disputes. This reflects the wide range of relationships that often arise in the context of international investments. The relevant factual scenarios are diverse, as are the types of actors who can be involved. Affected third parties may include creditors of ISDS claimants, local governments, indigenous or other affected communities, users of utilities or other public services, individuals or groups with competing claims to property at stake in investment disputes, and adverse parties in underlying or parallel litigation. The rights or interests held by affected third parties can be triggered or affected by ISDS disputes in a range of circumstances. Examples based on existing cases include where an investor-state dispute arises out of discrete, competing claims advanced in different legal fora between non-governmental actors, states, and investors, and when ISDS is used to challenge aspects of legal proceedings between an investor and other private parties, including the outcomes of those legal proceedings. At its 37th session, the working group identified participation by third parties in ISDS as an issue warranting consideration during Phase 3 of its work. Several states and observers made specific comments relevant to this topic, noting, for example, that the role and intent of amicus curiae submissions are not designed for situations where the actual rights of third parties are affected, and that participation by third parties is relevant for the legitimacy of the ISDS system. A number of state submissions made in advance of the 38th session also referred to the importance of enabling third-party participation, including beyond amicus curiae submissions. Discussions at the 37th session highlighted the impact that ISDS has on the rights and interests of third parties, but they also raise issues that are integral or relevant to the concerns that have already been identified by the Working Group for Reform. For example, participation by third parties whose rights or interests are at stake in an investment dispute can promote the correct interpretation and application of relevant legal norms and therefore lead to more correct and legitimate outcomes. To support the working group's consideration of these issues, and to support states in thinking about these issues in the context of negotiations, CCSI, working with the International Institute for Environment and Development and the International Institute for Sustainable Development, submitted to the UNCITRAL Secretariat a submission that both highlights how ISDS affects the rights of third parties and outlines potential options to better address the range of rights and interests at stake in investment disputes. The submission provides examples of how other legal jurisdictions and regimes address these issues. It seeks to raise questions for states to consider when thinking through how these issues could be addressed. It also elaborates on what insights could be gained from other jurisdictions and what those insights could mean for the next phase of the working group's deliberations. The submission and the options it outlines complement other submissions and solutions, including those on cross-cutting issues, termination of investment treaties and withdrawal of consent to ISDS, and third-party funding. We encourage you to take a look at the submission, and we'd be happy to discuss it with those interested. The submission is available at the following links. Please contact us if you have any questions. Thank you very much.